next week. Now, back to Silver Moments with Dr. Marsha Baltimore.
I want to tell you now about the new public law that was enacted in 1998. The name of the law is Public Law 105-339. I'm sure you're going to remember that, 105-339. But it's an employment act. And what it says, this is an act to amend Title V of the United States Code to provide that consideration may not be denied to preference eligibles applying for certain positions in competitive service and for other persons. So what does that mean? Preference eligibles, or veterans who have been separated from the armed forces under honorable conditions when they have finished with 3 years of service or more, may be not denied the opportunity to compete for vacant positions for which the agency making the announcement will accept applications from any individuals outside its own workforce. In other words, you can get a job anywhere if you're a veteran of 3 years with an honorable discharge. If you apply, there's a way to get at it. The area of consideration for all merit promotion announcements, which include the federal workforce, shall indicate that preference eligibles and veterans, that said veterans, who have been separated from the armed forces under honorable conditions after 3 years or more, are eligible to apply. This announcement shall be publicized. So what do? You look what happens if you apply and they turn you down. You can get an administrative redress, a preference eligible who alleges that an agency has violated an individual's rights under the statute of regulation may file a complaint with the Secretary of Labor. So you have a recourse to get the job if they turn you down the first time, and that's with the Secretary of Labor. This is now out of the veteran level, it's into the labor level. A complaint under this subsection must be filed within 60 days after the date of the alleged violation, which could include a refusal by the company to hire you on the basis of the fact you have a war-related injury, something like that. That would be a clear violation of this law. So you can get going with something that's in your hand that rejected you and send it, copy to the Secretary of Labor. And then your Secretary of Labor shall, upon request, provide technical assistance to a potential complainant and find out by investigation each complaint under subsection A. So the Department of Labor is obligated to check on what you're saying. And on the 61st day, or later than 15 days after the date on which the complaint receives the answer from the secretary, you can make an appeal. You can go all the way through the court with this. And certainly do one thing. Send your congressman a copy of what you're doing. If you're a veteran, for example, and you have a loss of a limb, and they won't give you a job because of that, you have rights. So go use your rights to the Department of Labor, the secretary. There's a whole chapter on this. I can't tell you everything, but it's very busy. And 12 months after you start submitting, you can submit your letter to your congressman to put it into the Congress. And there will be a judicial conference of the United States on your case of losing a job for a war-related injury. So you can work on that if you have what I just read to you, the injury, the war record, and the refusal by the company. You can go to the Department of Labor, copy to your congressman, always, when you're talking about federal. And then you can work it through. I hope you don't have that, but if you do, I hope that was helpful. So that is Section 4212 of Title 38, United States Code, on federal contracts on veterans' employment. You have big rights with that, gentlemen and ladies.